I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The Supreme Court has denied Donald Trump's emergency application to vacate the 11th Circuit's order, which granted the Department of Justice's motion for a partial stay, returning those 100 plus classified records to the Department of Justice that the Department of Justice obtained during the valid search warrant that was executed on August 8th. You'll recall Judge Eileen Cannon made that order on September 5th, granting Donald Trump's motion for judicial oversight. That is currently being appealed. Her entire assertion of equitable jurisdiction is currently being appealed on an expedited basis before the 11th Circuit Court of Appeals. In the interim, the Department of Justice filed a motion for partial stay with the 11th Circuit, saying, while Judge Eileen Cannon is wrong to have asserted jurisdiction in the first place, the urgent emergency relates to these 103 classified records we obtained during the August 8th search warrant. These are undoubtedly, indisputably our records. Donald Trump has not even claimed to have a possessory interest in these records, nor could he. They belong to the government. There are classified records, and we need them for our national security interests. We need them to pursue our criminal investigation into Donald Trump. And there, the 11th Circuit granted the Department of Justice's motion for partial stay, said on an emergency basis, you can have those records back. Donald Trump then appealed that 11th Circuit ruling. He filed an emergency application with the Supreme Court. The emergency application actually goes to Clarence Thomas, since he is the Supreme Court judge who has been assigned to rule on emergency orders relating to 11th Circuit rulings. Judge Clarence Thomas, in today's order, referred the matter to the full Supreme Court. One of the things that a supervising judge over the circuits can do when they're given these emergency applications, they can rule on it themselves. They can refer it to the full Supreme Court. And here, Justice Clarence Thomas referred it to the full Supreme Court. And here is what the order says. It is just a quick order. It says, case 228283, Trump v. United States. The application to vacate the stay entered by the United States Court of Appeals for the 11th Circuit on September 21, 2022, presented to Justice Thomas and by him referred to the court, is denied. And so what this means is that when Justice Thomas received the application, and after he ordered the Department of Justice to file their response brief, and they filed a 34-page response brief this week, he then referred it to the full Supreme Court, which denied the relief being requested. Now, in the Department of Justice, which they filed through the Solicitor General's office, what they argued is, of course, Donald Trump should not be entitled to the relief he wants, which is to give these 100 classified records back to the special master. The Department of Justice argued Donald Trump hasn't even argued the very basic factors that you are required to argue if you want that relief. The factors, if you're making this claim to ask the Supreme Court to intervene to overturn the 11th Circuit's order on a motion for partial stay returning these records, is the following. Number one, the case very likely would be reviewed by this court upon final disposition in the Court of Appeals. In other words, would the Supreme Court grant certiorari on this case? Does this case involve some novel issue of law or some split between the circuit courts of appeals such that this is a case the Supreme Court would actually even take up, one of those 1 to 3% of cases that the Supreme Court actually will even listen to in the first place? And here the Department of Justice argued in the brief that they filed this week, Donald Trump didn't even brief this issue. He didn't even try to answer this question or provide you with any guidance. He didn't even address this factor. The second factor, the Court of Appeals is demonstrably wrong in its application of accepted standards in deciding to issue the stay. And here, the Department of Justice argued all Donald Trump is claiming is that the 11th Circuit did not have appropriate jurisdiction to hear this case. And what the Department of Justice said was the 11th Circuit clearly had jurisdiction. Who didn't have jurisdiction is Judge Eileen Cannon. And the 11th Circuit had jurisdiction based on a variety of legal doctrines, whether it's pendant jurisdiction, which basically says that the 11th Circuit can engage in an interlocutory appeal or an appeal before a final judgment where issues are inextricably intertwined with traditional areas where courts of appeals would have the power to issue interlocutory orders. And here, the injunction issued by Judge Eileen Cannon ordering the Department of Justice not to use its own records in connection with the criminal investigation into Donald Trump, that's an unprecedented injunction. And the Department of Justice ordered pendant jurisdiction applies here because that is inextricably intertwined with the special master order. And Trump was arguing the special master aspect of Judge Eileen Cannon's order was non-appealable. And the Department of Justice said the injunction and the special master portion of the order are really inextricably intertwined. They're one and the same. And so the 11th Circuit is permitted to assert jurisdiction there. In any event, the Department of Justice said they don't even have to assert pendant jurisdiction because what Judge Eileen Cannon did, while she was very sloppy in her order actually was an overall injunction order. It's the type of thing the 11th Circuit can rule on an interlocutory basis. The special master aspect and the other aspect of the order enjoining the Department of Justice not to use the documents are one and the same order. Forget just being inextricably intertwined. Judge Eileen Cannon issued an injunction, and the injunction is what is being appealed from her September 5th order. And in any event, Judge Eileen Cannon's order should be viewed as a collateral order, which basically creates a situation where you can't unring the bell, such that if the Department of Justice was forced to show Donald Trump the classified records through the special master process, their entire criminal investigation would be undermined. Therefore, you can't unring the bell. It's a collateral order, or like a final order that would affect their final rights as the Department of Justice, another area where the 11th Circuit Court of Appeals would be permitted to make a ruling and to assert appellate jurisdiction. And so for all of those reasons, the 11th Circuit should have appellate jurisdiction. They made the ruling rightfully. There was 2 Trump judges, 1 Obama judge on that panel, and they returned those classified records to the Department of Justice appropriately. And finally, the third factor that the Department of Justice said, that if you were going to go to the Supreme Court and they were to grant an emergency order vacating the stay that was issued by the 11th Circuit, that you have to make a finding that Trump's rights may be seriously and irreparably injured by the stay. And the Department of Justice said Donald Trump can't be irreparably injured. They're not his documents. He stole classified records from the government that don't belong to him. How could you be irreparably injured when you are the thief that stole the records? Is the bank robber irreparably harmed when they steal the cash from the bank? That's essentially what Trump is claiming. And in any event, the Department of Justice points out Trump never even made the claim that he was irreparably injured at all. So he didn't even make the argument. And so the Department of Justice filed this brief earlier this week. The Supreme Court has now made its ruling. Again, short, terse ruling denying Donald Trump's emergency motion. I guess Trump thought, oh, my buddy Clarence Thomas is going to come to my defense here. And I told you, I said, look, as problematic as I think Clarence Thomas's decisions are, I said the factors here will not line up in a situation where Clarence Thomas could possibly, rule in Donald Trump's. I mean, he could do anything, but in any event, if Clarence Thomas was to even make that ruling in Donald Trump's favor, it would still be revisable eventually by the court. It would be temporary. So Clarence Thomas would be doing something that he would eventually be overturned by the full Supreme Court because the law is so clearly established here. It's not even a tough call. You can't steal classified records from the government and then derail a criminal investigation and then demand the documents back or demand they go to a special master process. That's just against the law. It's like the most basic of concepts. So now, with Donald Trump's emergency motion being denied by the Supreme Court, what does this all mean? It means the Department of Justice still has their 100 classified records. They are pursuing their ongoing criminal investigation. Like just yesterday, we learned additional information, right? The Trump employee, a former military aide at the White House who worked with Trump, was asked by Trump to move the records from the storage area after the grand jury subpoenaed those records. And so Donald Trump was trying to hide these records before the August 8th search warrant was executed at Mar-A-Lago. We're also aware that that was caught on the video surveillance footage. So the Department of Justice has the goods on Donald Trump as they pursue their criminal investigation. And also the 11th Circuit has ordered an expedited briefing schedule on the Department of Justice's overall appeal that Judge Eileen Cannon should not have exercised equitable jurisdiction in the first place. And what the Department of Justice there argued to the 11th Circuit is basically, look, the same analysis why you've found that Judge Eileen Cannon did not have equitable jurisdiction over the 103 classified records, that same analysis actually applies to the 11,000 other government records that Donald Trump stole, which are still part of this special master process. And 11th Circuit, you know the law. The law is very, very clear. There are these factors in this case from 1975 about the rare circumstances where a district court judge can just jump into a case that's not theirs, right? This case is before a magistrate judge. The magistrate judge signed the search warrant that was sent to it by the Department of Justice on August 5th, finding probable cause. That's Judge Reinhardt. That's who's supposed to have this. But in the rarest of circumstances where a district court judge is petitioned and the district court judge under this case called Ritchie finds that the Department of Justice engaged in such a callous disregard for the rights of the individual who they're investigating, then you could assert equitable jurisdiction if you then find these other factors like irreparable harm and this need for these records back. But you have to make that threshold finding of a callous disregard for the rights. Even in Judge Eileen Cannon's September 5th order, where she asserted equitable jurisdiction, her order said that there was not a callous disregard for the rights of Trump. There was no finding that that was done. And the 11th Circuit, in their order around September 21st, they basically said, look, your inquiry, Judge Eileen Cannon, should have ended right there. The moment you found no callous disregard, you shouldn't have asserted equitable jurisdiction, because that's the rarest of rare circumstances where you can even get involved in the case. And then the 11th Circuit went on to teach her and say, well, you claim that there's irreparable harm to Donald Trump. Why? Because you claim that he's a former president. So what? We're all citizens of the United States. He's not treated any different. He shouldn't be treated any special. And you can't steal records. As they say, Trump didn't even claim a possessory interest in these records. He's made no claim. He's made no official claim or formal claim that he's declassified these records, even though classification is not even at issue here. And regardless, he can't claim that he owns these records. These records belong to the executive branch currently. So how could he have irreparable harm? How could he claim a need for records back that don't belong to him? So that's what the 11th Circuit said there. And these are the issues, again, that the Department of Justice is going to raise in their appeal brief that they're filing regarding the overall rejection of the idea that Judge Eileen Cannon should have asserted equitable jurisdiction. The 11th Circuit ordered that this should be heard on an expedited briefing schedule. Opening brief is due October 14th. Trump gets to respond shortly thereafter. Department of Justice files a response brief. All this briefing will be done before November 20th. There may be oral argument, but I'm sure it'll happen quickly. So my prediction is that we are going to have an order by the 11th Circuit sometime in December, basically saying Judge Eileen Cannon should never have asserted jurisdiction in the first place. Expect a very scathing, incredibly scathing order from the 11th Circuit saying Judge Eileen Cannon was erroneous and wrong, and she should never have asserted jurisdiction in the first place. That is going to end the special master process. And in the meantime, the Department of Justice has its classified records. They won again before the Supreme Court. They won before the 11th Circuit. Donald Trump is losing everywhere except for that one district court judge who he installed in 2020, who's now exposed herself by going against the law in such an egregious way. Like, everybody in the legal community looks at Judge Aileen Cannon like a clown. And that may be fine for her, but she's a young judge. For the rest of her judicial career, every lawyer looks at you like a clown judge. You're not a serious judge. You don't follow the law. You are a despicable judge, Judge Aileen Cannon. That's how the legal community views you, and you're going to be overturned at every level. I don't even know how someone could appear before you, Judge Aileen Cannon, and take you seriously at all. Despicable, but the wheels of justice have turned in the right direction here. Bad news for Donald Trump. Great news for our democracy. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers, thanks to you. If you want to support independent media like this, here's what you can do. Head to patreon.com/MeidasTouch, patreon.com/MeidasTouch. That's patreon.com/MeidasTouch. Different membership tiers. It's a good way you can support us. We're not funded by any outside investors. Thank you so much. I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.